First of all, on behalf of IBRAC and of our Committee of Compliance, I would like to thank Rafael and Kyle so much for accepting the invitation. It is really an honor to have you guys here. I know that Rafaela knows a lot of the people who are participating in this meeting. Personally, I know she knows some people, and Kyle apparently also knows some of the Brazilians here. Kyle's not yet fluent in English, so we will have this, at least that's what he says. So we will do this in English. And so thank you very much. Kyle is a partner in the Special Matters and Investigations practice at King & Spalding in New York. He practices in white-collar criminal defense litigation, federal and state government investigations, corporate internal investigations, advises on corporate compliance programs. He has represented corporations and individuals in a wide array of matters, including FCPA and anti-corruption. And he has a fantastic CV here, and I'm just going to say that his experience will be very interesting for the topic that we will discuss. Rafaela is an associate also in the Special Matters and Investigations practices in King & Spalding's New York office. Just a side note here, I love this name, Special Matters and Investigation Practice. I think it's perfect. Rafaela has been with King & Spalding for a few years now, and she represents corporate and individual clients on matters related to financial crime, securities regulation, and she has experience in investigations conducted by the DOJ, the SEC, and others, and also in internal investigations. So the topic that we are going to discuss here, we have, talked to both Rafaela and Kyle, and we have conveyed to them the fact that in the committee we have been discussing, often issues involving settlements in Brazil, in particular settlements involving anti-corruption issues, and we have talked about how difficult sometimes it is to have competing authorities dealing with the same facts, and the many challenges that we face when we need to negotiate a settlement, that we have to coordinate all of these, all of the different authorities. And so Cecilia and I, we have been discussing this, and we thought that this would be a very interesting topic for our audience. We feel, sometimes in Brazil, we have the impression that in the US, everything works perfectly and smoothly, and we will find out if this is the case. So this is what we are going to discuss about. I also want to present here, for those who do not know her, Maria Cecilia Andrade. Maria Cecilia also is a coordinator of our compliance committee, and she's I dare to say that she's an expert in settlements in Brazil, because she has been negotiating various settlements, both in antitrust and anti-corruption. She was in the compliance area. She was in charge of the compliance area of a big construction company. And so we are very happy to have Cecilia also participate as a moderator and possibly posing questions. So I think I talked a lot already, and I'll leave it to Rafaela and Kyle. Thanks again.
So, hi everyone, good morning, and thanks for joining us today. I am really extremely happy to be here, and I want to first say thank you to the committee for the invitation, especially Mariana and Vitor Jorge, who put this, made the connection, and to Cecilia. I'm particularly happy because I know IBRAC from the time I practiced in Brazil, and I remember going to many interesting events. And so I hope you find this presentation helpful. So I'm gonna show you. Kyle, do you wanna just say some words, or can I go ahead and go to the agenda of the day?
No, I'll leave it to you, Rafa. I'll just reiterate what you were saying, everybody, which is that we're really, really excited to be here. Really excited to chat with all you guys about an issue that has, gotten a lot of press and a lot of attention over the years, but still continues to be one I think that, requires careful analysis and thought when you're actually focused on this and dealing with the government. And so I just wanted to say that, we do have some material that's prepared, kind of ready for everybody, but please feel free to stop us, interrupt us, ask questions. I mean, the goal here is to make this useful for everybody that's here, right? And if we're just droning on about something that's not particularly interesting, or you want to divert the discussion or conversation in a direction that people are more interested in, I mean, please feel free to do so. We're not wedded to what we prepared. We just want to make this as beneficial for everybody. But Rafael, please get us started.
So let's go ahead. So this is the agenda for the meeting today. So give an overview of the DOJ and SEC investigations. We'll discuss the types of resolution available, the policies currently in place, differences between the resolutions, and what are the factors taken into account in the negotiation process. And as Kyle said, we are happy to answer your questions at any time during and after the presentation. So, so shall we get started, Kyle, with the introduction?
Sure, let's do that. So, as Rafael was saying, our focus today is going to be on the Department of Justice and the Securities and Exchange Commission in the United States, which are two federal law enforcement organizations in the U.S. And the DOJ is the primary agency responsible for enforcing criminal law in the United States. It does a lot of other things and is composed of dozens of different agencies, many of which I'm sure folks have heard of, like the Federal Bureau of Investigation, the FBI, or others. But, for our purposes, I think what, we're talking about here in the context of, corporate settlements, corporate criminal resolutions, we're going to be focused on the DOJ's criminal prerogatives, right, as a federal law enforcement agency in the U.S. And, these are investigated by a number of what we call United States attorneys' offices in the United States. There are 93 of them. And this is where the enforcement, matters are done, right? This is where they're investigated and prosecuted, oftentimes with coordination with attorneys of the DOJ in Main Justice, which is in Washington, D.C., and other particular divisions of the Justice Department as needed, depending on the type of case and kind of what's in focus. It's important, I think, to say at the outset that each state within the United States has its own system, right? Its own criminal justice system, its own laws, and its own, way of enforcing things. I think this is similar in Brazil and other places. The DOJ is, again, responsible for the federal issues. And there are some differences, right? And we can discuss those if those are interesting to folks. I mean, one example is that a grand jury must be used to charge a federal felony, right? Unless that's waived. But not all states require grand juries to actually charge defendants. And there's a number of other sort of procedural intricacies in the different systems. But again, for our purposes, I think a lot of what we wanted to discuss and share our insights with you all was on the federal side with the DOJ and the SEC. So Rafa, why don't I kick it over to you to talk about what the SEC does?
Yeah, so just turning to the SEC. So the SEC is responsible for overseeing the securities market and certain market participants, such as broker-dealers, investment advisors, credit rating agencies, and some organizations as well, like FINRA. You need to think that the mandate of the commission is to protect the investors and the U.S. capital markets. The way it works, the investigation part is that the SEC has different divisions, and there's an enforcement division who's responsible for conducting the enforcement cases. It is headquartered in DC, but also has 11 regional offices. And every year, the Division of Enforcement brings hundreds of civil enforcement actions against individuals and companies for violations of securities laws. These are it's a federal law. Just to give you an idea of the numbers, so every year the Enforcement Division publishes an annual report. And last year, for example, the SEC brought 715 enforcement actions, which was an impressive number considering that they started working from home in May. It was just a slightly lower number than 2019, which was 862 cases. And to give you some color on the size of the monetary remedies, and in 2020, the Commission's actions were ordered to pay a total of $4.6 billion, 3.5 in disgorgement, and 1 billion, a bit more than 1 billion in civil penalties. So I would like to give you an overview of how an investigation usually begins. They are different forms that an investigation can start, and we're gonna just highlight some of them. So many times we see referrals from one law enforcement agency to another. So for example, it could be a case that started with the SEC and then they referred the case to the DOJ. It could start with whistleblowers. I think you are all familiar with the term, but usually company insiders who provide information of companies' fraudulent behavior to the government. It could start just with press reports or one article or a series of articles about something that caught their attention. Also thinking specifically about the SEC, the SEC has been focusing on the use of data analytics to identify misconduct, and this is something that has been increasing. We have seen every year more cases being brought with the use of data. And another thing that it's interesting, I think, is I mentioned the different divisions within the SEC. So they have a division of examinations, and this division of examinations regulates some type of participants. And depending on how the year exam goes, like if they find something wrong, they could refer the case to the enforcement division. The division examinations is not able to examine like all market participants. It's just focused on certain type of participants like financial advisors and broker dealers, and they select like they publish every year a priority report explaining what are their priorities and how they want to choose who's going to be examined for the year. I'll turn to Kyle now, who's going to explain how in practice an investigation moves and goes to the discovery phase.
Yeah, thanks, Rafael. And it's a good thing to keep in mind that, you know, these things can really start in a number of different ways. You know, we've seen lots of cases start in different ways, and the way that they get to companies, you know, can sometimes be after a long, you know, series of investigative efforts by the agencies or the prosecutors that are involved. And, you know, I mean, the reason why we're walking through this a little bit at the beginning here is because, you know, the ultimate topic that we want to really dive into with this group is resolutions, right? I mean, you know, what are the forms of the various resolutions and settlement types that you can enter into with the Justice Department or with the SEC? And a key element of any ultimate resolution or, you know, settlement of charges or of, you know, misconduct that's being investigated is the actual investigation. right? I mean, are the facts that are uncovered and are the components of this? And so this is why we're spending a little bit of time walking through this process, because there is no resolution without a factual basis for, coming to that resolution and some agreement as to the conduct that is going to be in focus and in scope of that resolution. So on the DOJ side, I mean, you're seeing similar sort of fact gathering and investigative techniques as the SEC and other federal agencies in the United States use. There's going to be document requests in the form of subpoenas or other types of requests. There are search warrants. This is, when a bunch of FBI agents show up somewhere and start taking stuff, which people might be familiar with the scene. There's also conducting interviews, right, of witnesses or others. And then, in a corporate context, something that we see a lot is actual presentations that are made by, the defendant's counsel to the government, on the results of, for example, an internal investigation of a particular issue. The Justice Department is supported by a number of agencies. I kind of mentioned that a little bit earlier, but the FBI does a lot of investigative work that contributes to these types of investigations. Homeland Security is another big one, especially when it comes to international investigations and cross-border issues and issues that sort of span different jurisdictions. And these investigators are helping the prosecutors basically understand the case, right? Understand the details of the case. And oftentimes prosecutors at the Justice Department will work with, one or several agencies, right, to compile this information and put together the details of the matter. But one topic I want to touch on here, which may be of interest, is the different way that the Justice Department may view people or companies that are in focus of their investigation, right, or are part or in scope of the investigation. And some of these terms are actually defined by Justice Department guidance on this issue. The first one is called the subject of an investigation. And according to, DOJ policies and guidance, this is someone whose conduct is within the scope of the grand jury's investigation, right? And so, this is someone who oftentimes law enforcement is going to want to interview in an effort to obtain some evidence, potentially against that person, right? It's a little bit of a nebulous category. And I think that, folks who have been, told that they're a subject or are in that category as part of an investigation have to be very careful about how they're going to proceed. The next level, though, is what's actually called a target of an investigation, right? And a target is someone that, the prosecutor, the grand jury has substantial evidence that links them to the commission of the crime that is being investigated, right? I mean, this is someone who is, essentially a potential defendant, criminal defendant in the case. Sometimes they receive what's called a target letter informing them of that status, which basically just says, you're a target of a federal criminal investigation. The prosecutors may want to, start discussions about that. The other category, which I want to mention here, is a witness. A witness is someone who, the government, at least at that time, doesn't have any reason to believe they have criminal exposure, right? They probably have relevant information about the investigation or about the matters that are being looked at. And this is someone who can provide, information to law enforcement through a field interview or maybe at the U.S. Attorney's Office, and also sometimes is brought before the grand jury to actually testify. Now, the thing, though, to be careful whenever you're dealing with an investigation like this is even if you find your client or someone who's involved in this case in the witness category, is that it is a crime to lie to the government when you are, being interviewed for things like this. And so, you have to be just very careful about how you approach it. And you don't want to start off as a witness, but end up causing problems for yourself based on the testimony that you provide. So, Rafa, with that, why don't I kick it back to you on the SEC side?
Sure. So the SEC, it's similar to what Kyle just told us, but there are a few things that I want to highlight. So typically, the SEC will first conduct just an informal inquiry. And this is like a preliminary phase, let's say. And at this point, like the SEC staff will gather some minimal information to understand whether they will move forward with a formal investigation. And at this point, they will issue some requests for information and requests for documents. They may ask for voluntary interview of witnesses. And then in order for the SEC to have authority to issue a subpoena for production of documents and to compel testimony, the SEC will enter a formal order of investigation, which is basically going to describe the nature of the investigation, what are the facts, and the statutory violations. And with that formal order, the SEC can issue subpoenas compelling witnesses to testify and to produce documents. One thing that I think it's interesting and you should keep in mind is that in many times, and you all know, like regulators you can have more than one regulator asking questions to you about like the same facts, but each regulator will conduct their own investigation, and they may have, and in my experience, I have seen that like they have different areas of focus. So one thing, like the client, like we as company counsel or counsel of an individual, will always try to coordinate the requests and find a way to make it this more efficient, right? So company counsel will always start a dialogue with the regulators, trying to coordinate the requests. And things that we have seen that usually happen is that you can produce like the same documents that we are producing to one regulator, you can share with the other just to make sure they have the same information. Or you can, if you are giving a presentation to the SEC, for example, and the CFTC or the DOJ is also investigating the company for about similar facts, you can invite them also to attend this meeting. So this is something that happens often, but it's not. They don't need to accept that. So it's very important to have a good dialogue with them. One thing that I forgot to say, but I think it's important just to keep in mind here, is that when like the SEC or the DOJ start with like the first inquiry of documents or information, that's the moment that usually the company will hire counsel, and it's very important to issue a preservation notice to preserve all documents and make sure like we will have, like, for the time period under investigation, we will be able to provide all information and answer the questions that the regulators may have. So I think we can start with the resolutions now. Kyle, I'll turn to you.
Yep. Thanks, Rafaela. And it's certainly an important point in terms of preservation and coordination, as you were discussing. And I think that this becomes even more important when you get into, the concepts of coming to a resolution, right? And the structure of that, which is what we'll touch on a little bit here. Basically, once you get to a point in an investigation where, the government prosecutors that you're dealing with have gathered enough information about the issues at hand, then, you turn to some discussions about the contours of a potential resolution. What I want to walk through a little bit is some of the key elements of those discussions, and how they're presented to the government, how they're sort of viewed by the government, and how those can factor into ultimately the form of the resolution that's taken, and perhaps some of the undertakings that are included in that resolution. So in getting there, if you're a lawyer, right, in private practice, and you're, making a series of presentations to prosecutors, you're basically attempting to convince them to, to not proceed with some type of negotiated resolution, to decline, right? I think that's generally the best case scenario if you find yourself in the crosshairs of something like this. Or again, if you ultimately do find yourself in a situation where you need to move forward, to adopt a particular type of resolution. And this is where we're going to get into the discussion of, for example, deferred prosecution agreements or guilty pleas or other types of resolutions. It's a complex process. It's driven by both the facts of the case, it's driven by the law, It's also driven by the policies of the department, and potentially in cross-border cases, which might be of interest to the audience here. I mean, there could be other international dimensions and dynamics that are at play when you're going through the resolution phase. So, there's a couple of different things to bear in mind as you work through the process. But needless to say, it's it can be very complex, and you have to really think through how you're presenting your client and your case, the government, when you're going into it. Again, I mean, the first and best outcome, I think, is a declination, right? I mean, basically where the DOJ decides not to pursue any type of resolution. Now, this can come either, formally through the issuance of a declination letter, which the DOJ sometimes does, or in my experience, much more frequently, they just kind of go away, right? I mean, the investigation just sort of ends, and you don't hear about it anymore, and it's effectively over. Without any, discussion of, like I said, a type of negotiated resolution. There's a sort of newer option, which I believe is called a declination with disgorgement, that you've seen in some of the more recent, like FCPA cases, for example, which is technically a declination of, proceeding on that basis. And there's no fines or penalties, but there is a disgorgement of ill-gotten profits related to the matter at hand. So that's a kind of tweak that's been happening a bit more recently. But basically, if you're not able to secure a declination or get the government to just sort of go away based on your advocacy and like I said, the facts and law of the case, there's a few different flavors of the ultimate resolution. There's a non-prosecution agreement, there's a deferred prosecution agreement, and the in many respects, perhaps the worst case scenario is a guilty plea. And all of these are actually applicable to both individuals, right? I mean, individuals who are subject to a criminal investigation, but also to companies. Although the paradigm that gets applied here, depending on whether it's a corporation or an individual, can actually be kind of tricky. As with many corporate criminal issues, and there's been a lot of ink spilled on this and discussions and scholarly work on it for many years. There is some level of metaphor that's involved when you're imposing, the U.S. federal criminal system on a company, right? And I mean, that's something we can talk about more if people are interested in. But the bottom line is that these different types of agreements are in fact available to both companies and individuals, and that's going to be a discussion point as you work towards ending the matter with the government. One thing to bear in mind is that as you negotiate, the form of the resolution, and you negotiate the structure of the resolution, you need to be cautious of the undertakings, right, and the conditions that might attach to those resolutions. Whether it's obviously fines and payment amounts get a lot of discussion, but also there's cooperation requirements sometimes quite specific cooperation requirements, like you must do X thing or provide X information. As a condition of an agreement. And so, again, it's something to consider as you're developing the framework for the agreements. And again, I mean, I don't want to be lost on folks that these are all negotiated resolutions, right? I mean, you have every right to continue to fight your case and proceed on to trial, and many individuals do, as people will be familiar with. I mean, just from watching the press and seeing some of these cases turn out. In the corporate context, that is a much more difficult decision. It is quite rare for a corporation to fight criminal charges in court. It does happen. It has happened, but more often corporations seek the certainty of negotiated resolution, or the certainty of ideally like a declination or some other way to resolve a matter, as opposed to fighting down in court, because a company just has a different set of issues that they're thinking about. But anyways, it's just something that sometimes gets lost in this discussion, that of course, you can fight your way and have your day in court and take case to trial if you so choose. One of the things that I wanted to, focus on here is that, again, going back to the sort of corporate metaphor, companies don't just act on their own, right? Companies are made up of individuals, and the conduct of individuals is, of course, very closely intertwined with discussions about charging corporations. And so, just because a case was resolved for a certain way for a company doesn't necessarily mean that it would be resolved in a similar way for individuals that worked at that company or individuals that were associated with this conduct in some other manner. And so again, there's a lot of complicated dynamics here in terms of, how the Justice Department might view the conduct of a corporation, how a corporation might be incentivized to deal with the Justice Department in terms of negotiating a resolution, and how specific individuals who are involved in this might be viewed and how they might want to move forward in terms of, dealing with their own potential criminal exposure. So there's a lot of moving pieces here. And that's just within the context of, say a DOJ prosecution. As Rafaela was mentioning earlier, if you get other agencies involved and the SEC is also knocking and, potentially foreign enforcement agencies are involved, it can be even more complicated. But the key is that, I don't think the Justice Department is shying away from this, and they make it very explicit in some of their guidance, which we've excerpted here on this slide. This is, what we're talking about in terms of the different types of agreements that are available, deferred prosecution agreements, non-prosecution agreements, and, to promote compliance with the law and that sort of thing. Now, what the DOJ would also say is that, companies should not be treated more leniently because of, their artificial nature or what have you. The vigorous enforcement of the criminal laws against corporate wrongdoers is something that the DOJ is very focused on and considers to be a priority. So various flavors here are on the table, and I think it's important for any lawyers who are advising companies to be aware of that, as you discuss various types of resolutions. Prosecutors have the discretion to pursue a wide variety of approaches here, depending, again, on what's going on in the case. And so, what I think that might be helpful to continue to discuss a little bit with this group is that, there are different factors that Justice Department prosecutors take into account when looking at corporations and deciding how to go forward on these types of resolutions. Right. And I think that in practice, these are really critical guidelines to bear in mind during the investigation phase, actually, of any government enforcement matter that you might be dealing with. Not exhaustive. Certain factors may be more relevant or less relevant depending on the case. And in my experience, a lot of this is art and not science, too. Right. These are factors that, can be considered, but they aren't necessarily determinative depending on what's going on in your particular matter. But I think that the factors that DOJ has set out when they're considering how to resolve cases with companies are very important for defense lawyers, to keep in mind if you're representing companies or in-house lawyers who are working at companies to consider, right? Because this can be driving your arguments, right? This can be a structure for how you're advocating to the government in terms of trying to negotiate the best and least, amount of punishment, depending on what the matter is, right? And so I just want to tick through these factors really quickly. And just provide a bit of insight on them, because like I said, I think that in order to understand how you come to a resolution with the government, you think through these types of factors and weigh them out and consider where your conduct fits into them in terms of what type of resolution might ultimately be appropriate to dispose that case. I think any of these factors could be a discussion in and of themselves, and many of them are also familiar to other types of government enforcement matters. These are certainly topics that are of interest to the SEC, as Rafaela would explain, or other government enforcement agencies around the world, right? So the first one is what's called the nature and the seriousness of the offense, right? This includes the risk of the harm to the public, applicable policies and priorities of the Justice Department, and particular categories of crime and that sort of thing. And the way that I think DOJ thinks about that factor is, if there is an angle here that makes the conduct significantly worse from potentially a policy perspective, you have if there's a national security or a terrorism angle to the particular case and the facts that are at issue that might enhance the seriousness of what you're seeing. And I think that from an advocacy standpoint, as a lawyer, one of the things that you might want to bear in mind here is might be a place to compare yourself favorably to others. In other words, to say, in our case, it's not as bad as these cases that have been prosecuted for similar situations, right? Maybe we have fewer employees who are involved in something. Maybe our exposure just isn't as great in terms of the overall numbers of whatever is being discussed. And so again, nature and seriousness of the offense can take on, different dimensions, and it's a way to frame, your position with the government. Another factor, and sort of similar in some ways, is the pervasiveness of the wrongdoing within the corporation, right? And here, one important point is the complicity and potentially the condoning of the wrongdoing by management, right? I mean, so now you're talking about basically how high up does knowledge or perhaps even instructing some of the misconduct at issue go. And so that's when you start looking at issues like management knowledge and involvement, right? I mean, is there evidence here that shows that the misconduct that we're talking about was blessed at a very high level or encouraged at a higher level, or what, are we really talking about more rogue actors at a lower level who were doing something that really was against all of the policies and procedures of the organization, and they were able to intentionally evade that, right? So I mean, that's kind of the thing that gets discussed in the context of that factor. Another factor is the corporation's history, right? Were there any similar misconduct or issues in the past? Which, by the way, can include both criminal and civil and regulatory actions, right? I mean, it wouldn't just necessarily be, similar criminal actions. And so, for example, for financial cases, oftentimes you see whether or not there are regulatory issues involving, those institutions that might play into how the DOJ would view the conduct of that company. Another factor that goes into these discussions, which I think gets discussed a lot in this context, is the cooperation, right, of the company. The corporation's willingness to cooperate, including, what was going on with particular individuals within the company. I think that there's, like I said, I mean, an entire session could be spent just on cooperation and what that means and the extent of it and kind of, how it's viewed in the context of these types of investigations. But, I mean, the basic things are, is the company providing information, right? Is the company making it difficult for the Justice Department or for other prosecutors to access information? How helpful was that information? Was it fighting about things, that made it more difficult for the prosecutors to get to what they needed to get to in terms of the case? Did the company facilitate, access to individuals or to particular categories of data? And this is not necessarily a straightforward topic, to say the least. I mean, one area where it gets complicated is where, especially in international cases, where sometimes there are local laws in the jurisdiction where the company operates that prevent it from doing certain things. Either providing certain categories of data or there are employment restrictions around how you deal with employees, and providing law enforcement access to those people can cause a lot of complications. And so it's not as straightforward as just saying whatever the government asks for, have you done it? There can be like I said, a very, very complex series of discussions around what it means to fully cooperate in the ambit of that cooperation. Also of more recent interest is a factor about the compliance program of companies. Basically the effectiveness, the adequacy of a company's compliance program. This is again probably could be its own session in terms of how compliance programs are structured, how they're viewed, the trainings that were in place, the policies that were in place, the investments and improvements to the corporate compliance program and the internal controls and all of that sort of thing. One point I like to try to emphasize here, if it's applicable in the case, is were any of the policies and procedures of a particular company industry leading, right, on this thing? I mean, were they really setting the gold standard, if you will, in terms of how they were approaching this particular issue and making sure that they were followed and trying to prevent the kind of misconduct that you're focused on. But again, I mean, the adequacy of a compliance program and how that's viewed by DOJ is a very long and complex topic, but it's certainly an important one. Another one I'll quickly touch on is disclosures of the wrongdoing, right? I mean, the corporation's timely and voluntary disclosure. When you see the declination letters that I mentioned earlier, oftentimes they discuss the value of self-disclosure, right? And I mean, I think that this is trying to be promoted. The message to the corporate community is that, if you come forward and do a self-disclosure, then, you can get a lot of credit for doing that. And so, the disclosure issue is always going to be an important factor. When did you disclose? How early was it? How complete was it? is certainly another important part of this, as you look at these sorts of issues. Let's see. I want to kind of speed up a little bit here, but another important one to consider, I think, is the collateral consequences. And that's something that's certainly relevant to any type of negotiated resolution with the government involving a corporation. This is basically, is there a disproportionate harm to shareholders, to employees, to other people who have no relationship to the misconduct, right? They're not personally culpable, as well as the impact on the public that could occur from, prosecuting a company. And, I think that part of this is just, again, our metaphor that I keep going back to. You can't put a company in jail. You cannot do that. And so the question is, what is the punishment, right? And the punishment that it's exacted on the company, and how does that affect people that had nothing to do with the conduct that is at issue? And this goes to even the owners of a public company, for example. The shareholders at time one, when the misconduct was occurring, could be totally different than the shareholders at time two, when you're actually negotiating with the government about, how to deal with that misconduct. And so, the collateral consequences discussion of these resolutions, I think, is something that's really, really important. Especially when you're talking about big companies. We use a phrase in the United States: systemically important companies that have a deep relationship with, for example, the financial system, the large banks, others that are just very interconnected with different parts of the economy. What is the impact of some of these resolutions on a company that occupies that position, right? Is there going to be a systemic impact here, a systemic risk on the broader market? Again, we're now talking about consequences and effects that are completely divorced from the conduct that we might be discussing in terms of how to get to a resolution, the bribery or the money laundering or whatever it happens to be. This is just impact on in many respects totally innocent third parties. So these are the types of issues that you discuss when you're trying to come to a resolution with the government. This is the type of argument that you make. Right. That if, the DOJ or the team that you're dealing with is putting forward a particular type of resolution, you have to, imagine what those consequences are going to be. Right. And really think those through and work those through with your client. And sometimes, have a lot of detailed discussions with the Justice Department about what that will mean. Right. And how that will be how that will be dealt with in the context of the ultimate format of the resolution. There's a couple other factors, again, I'm trying to move a little bit more quickly here, being conscious of the time, but, I really wanted to give folks a flavor for those discussions, right? Because I think that, when you're talking about corporate criminal resolutions, right, deferred prosecution agreements, non-prosecution agreements, guilty pleas, you have to think about how you come to those resolutions, right? And what the consideration of the various factors are of the corporation's conduct, understanding that a corporation is a sort of, it's a different type of entity, it's a different type of, legal situation than dealing with an individual, and the various considerations that go into those discussions as you work your way towards these resolutions. So I'll kick it back to Rafa now to walk us through some of the different types of the resolutions in detail. But again, I did want to give folks the flavor of the type of arguments and the type of issues that come up as you negotiate.
Thanks, Kyle. So let's just go back to this slide. I just want to explain a bit like the type of agreements and the differences among them. So the NPA is a non-prosecution agreement, so no formal charges are filed, and it's an agreement between the parties, between the prosecutors and the company or the individual, with a term, and during that term, the company or the individual needs to comply with the conditions that are set there. And one interesting example of a case that was settled last year is a case with Power Solutions International. It's a company from a U.S. company, and it was a settlement with NPA, with the DOJ, with a parallel SEC investigation. and a civil class action settlement. And just going back to what Kyle was telling us about the collateral consequences and whether the company has financial conditions to pay the monetary penalties. Like in this case, the DOJ recognized that the company could not pay the criminal fine due to its financial condition, and the company just paid the civil fine to the SEC, and of course a settlement with the class action. I just want to go over some of the factors considered by the DOJ in this NPA. So under the NPA, like, the company will not be criminally prosecuted, and the obligations under the agreement, which had a 10 years term, was to continue providing cooperation in the criminal prosecutions of the individuals, company's former executives. And the company also had to strengthen its compliance program and provide periodic updates on the compliance program. So the DOJ, it's very important that the part that Kyle was explaining to us, because at the end, the facts will lead to the type of the agreement. So how much you cooperated, what was the seriousness of the offense, that would be considered how you're gonna reach the type of decision or the type of settlement. So here, like, the DOJ recognized that it was not a voluntary disclosure, because the company did not voluntarily disclose the conduct to the DOJ, but the DOJ highlighted that the company hired an outside counsel and conducted an investigation and provided updates on the investigation to the DOJ, disclosed the results of the investigation to the DOJ as soon as the investigation was completed. The company also removed the executives involved in the conduct and implemented some remedial measures. So the DOJ considered the full corporation credit and highlighted that company counsel was always available to provide and give information and give presentations to the prosecutors. One interesting thing is that the company waived the attorney-client privilege and work product protection, aiming to provide additional information to the DOJ, which is a big thing, and it was for sure, like, considered in reaching this negotiation. And the more interesting aspect, I think, is that the DOJ recognized that the company was not able to pay the criminal penalty, as I mentioned, and not even if they had a reasonable installment schedule, because the company had already to pay a $8.5 million settlement. And I think this demonstrates, like, how important it is to coordinate the negotiation of the penalty amount with the regulator. So I'm sure, like, it was a settlement on the same day with the SEC and the DOJ, and there were discussions about how they would do with the penalty, for sure, because you need to discuss that if the company won't be able to continue. And it was expressly that the company would seriously be jeopardized and would not be able to continue if there was a criminal penalty. So just turning to the deferred prosecution agreement, it's another type of agreement, but at this, differently from the NPA, now here the prosecutors file a criminal charge with the court, and the DPA is approved by a federal judge. The DPA has a sunset period in the sense that the charges are subsequently dismissed as long as the corporation complies with the requirement of the agreement. The DPA is filed with the court, but actually the court has a limited role over the DPA itself. One interesting case that we saw recently is a case involving Brazil, an ex-DPA matter settled with Amic Foster, and it was a DPA with the DOJ, the settlement with the MPF, and the settlement with the SEC. I'm not going over the details. I just want to highlight that we were discussing like the monetary payment, and it was a case that there was a coordination again, because you see that they had to discuss which country would get how much which country would get. So Brazil got like 6 million, the US 7.6 million, and the UK 4.5 million. The DOJ considered that the company did not voluntarily disclose the conduct and the nature and the seriousness of the offense, which lasted for many years and involved high-level executive, and gave credit for the company's cooperation. I think we just need to give some additional details on the guilty plea that I'll turn to Kyle.
Thanks, Rafael. And I see some questions coming in too, which we can try to address because I know we're running short on time here. Bottom line is any of these topics that Rafael and I are discussing here could almost all be their own presentation. So we're trying to get through a lot of dense material and very complicated issues relatively quickly. But just to touch on guilty pleas, I mean, this is obviously an extremely harsh punishment for both an individual or a company. This is basically a situation where the defendant stands up in court and says, I committed these crimes, right? I mean, that's part of the guilty plea process and the sentencing process. And there's been a few major corporate guilty pleas that have been extracted. I think that the interesting part here to bear in mind as a practitioner is which entity enters into the agreement, which by the way is applicable to the NPA and DPAs that Rafa was discussing as well. But you want to think about, is this something the parent of a company is going to enter? Are they actually going to be the piece of the company that enters the guilty plea, or a subsidiary, or is there a foreign affiliate, a non-US affiliate that enters it? That's an extremely important consideration, because if you are convicted, that might have an impact on your licenses. That might have an impact on, debarment, suspension proceedings, and all of that sort of thing. And it can get very complicated in terms of, the form of the resolution and what entity takes the agreement in terms of, some of its other market activities. So a guilty plea is an extremely serious consequence. Maybe Mariana, should we try to address questions? Should we keep going? We can talk about resolving the matter with the SEC. I don't know, Rafa, maybe we give it like a minute on that and then we try to turn to the questions.
Yes, I would suggest that you continue. We can extend it 10 minutes if that's okay for you. So you have the chance to address and the issues that you wish to address, and also maybe answer the questions. So feel free. Okay. I think it's great. It's great. Very, very instructional. Thanks so much.
So maybe let's just move to the SEC and then we go to the questions at the end. The SEC, I want to discuss the SEC process of negotiation. So first of all, like the commission has stated that it is often in the public interest to pursue a reasonable and consensual resolution of the matter. As the former chairman, Jay Clayton, said, an appropriate craft settlement can be preferable than pursuing to a litigated resolution. So at the end, like the sooner the harmed investors are compensated and the conduct is remediated and penalties are imposed, the better it is. For our discussion today, I want to focus on the administrative settlements. So the best scenario, of course, as Kyle mentioned as well, is when the SEC staff does not recommend an enforcement action to the commission and closes the investigation. However, in many cases, that isn't the outcome. And the next question is like whether parties are willing to settle or not, and what, in which terms. So usually you have like the SEC staff, which is like the group that is conducting the investigation, who is like having the dialogue with the counsel. And this staff is going, if there is a settlement, is going to propose the settlement to the commission, and the commission needs to approve the settlement. So just to give you an idea of how is the dynamic inside the SEC. So in most of the cases, like the settlement discussions, they will begin right after the conclusion of witness testimony, which many times we call this as a pre-Wells process. So often the SEC staff will offer the party opportunity to discuss a settlement. And this happens when they have concluded their investigation and they have a robust record of the facts. So now during the pandemic, for example, this was happening usually in a video call. So the staff will give the parties an overview of what are the violations and what are the facts that they think constituted this violation. And having this overview of the SEC view, they will give the parties an opportunity to present a white paper. And this white paper is a submission, which is a advocacy submission with, we're gonna prepare like the facts, and there's also the legal component, defending why we don't think defending the client, basically, why these are not the violations. And after this point, like the SEC will, of course, reveal our white paper, and then we'll have another meeting where they will present their conclusions. And basically at this point, they will ask whether or not the company or the individual is interested in continuing with the settlement conversation. I think what is important to keep in mind is like you need to understand what is the SEC goal in pursuing that case, like why they are focused on the conduct. Is there like sometimes there are specific initiatives focused on some types of conduct. You should think like, is that the case here? You need to think like, what are the deal breakers for you and for them? One thing that I have seen that it's very difficult, it's for individuals to agree with a bar or a suspension. So many times the SEC wants the individual to be away and away from practicing as an accountant or as a CFO of a public company, with that view of protecting the investors. And this is usually a very complicated discussion because, of course, like the person doesn't want to stop working, right? It affects directly the career. The other thing to assess is the litigation risk. And what I mean by litigation risk is like, how likely is that the SEC will prevail in court? So if we don't have a settlement here, and the SEC goes to court with and file a complaint, is it likely that like they will prevail or not? So this is something that the SEC will consider, and we, of course, as company counsel or individual counsel will consider as well. Another important thing is to think about the remedies applied in other comparable cases. Normally, like in this overview of that the SEC will give to you of their views of the matter, of the facts and violations, they will also mention comparable cases. And they will say, oh, in this case, we applied this civil penalty, and we applied this bar for example, 3 years. And we think this is also applicable to your case because it's similar, for example. And at the end, like you need to propose a compromise and something that both parties can accept. And there will be for sure back and forth on the charges and the penalties. Usually calculating the civil penalty amount is something that there are different methodologies to calculate, and it's really not precise. So the SEC can calculate in a way and you can calculate in another way. And so it's hard to, there's no exact science with the penalty amount. There's the disgorgement component that in some cases, it's also a big financial component of the settlement. So disgorgement of illicit gains, the suspension that I mentioned, and many times there are other undertakings as part of the agreement, such as having an independent compliance advisor or filing compliance reports. As Kyle mentioned, for the DOJ, like the cooperation and remediation efforts, the SEC will also analyze that. There's a policy called the seaboard factors, and under this policy, like the 4 main areas that the SEC will look is like self-policing, which is basically if prior to discovery the misconduct, like, so were the company's control effective? Did the company keep adequate books and records? What was the tone of the top at this company? Was there pressure to achieve results? So I think these are questions that they will think about when they are thinking about the self-policing component. The second component of the seaboard factors is the self-reporting. It's the same thing with the DOJ, like whether they disclose the conduct. Another component is the cooperation, which is basically the company conducted a comprehensive internal investigation and shared the results of the investigation with the staff. Was the company facilitating employee interviews? Did the company sign a tolling agreement? Which tolling agreements when you basically extend the statute of limitation period. So you tool to that, and this is counted as a cooperation component. You can also waive privilege claims and voluntarily produce some documents. And the last component of this, the seaboard factors, is the remediation, which is basically like after this finding this misconduct, like what the company did to solve the failures. Just trying to speed up here as well. So the SEC doesn't need to have this pre-Wells phase. The SEC can just go directly to a phase called Wells, which is formal. It's not informal, as I described before, that you have like a number of meetings with back and forth. Wells notice is a preliminary determination by the staff to recommend to the commission that a civil enforcement action should be brought against this company or this individual. And I think this is a scenario that, like, the best thing is to avoid that, because the Wells notice trigger also a time, trigger the time. So you have 180 days for the SEC to commence an enforcement procedure, and this also may trigger some disclosure obligations. So just trying to finish this SEC part. So I think the big question is, like, why to settle? And of course, like, every case is different, and whether or not settling is the best option will depend on the circumstances of each case. However, settling with the SEC can give significant benefits, including the opportunity of having like an either admit nor deny settlement with the allegations. Of course, also litigating is very expensive, and you have the risk of litigating. On top of that, like, the SEC will file a complaint on court, and it's very likely that instead of having a settlement language that many times is negotiated, so you can negotiate with the SEC exactly the language that will be public. When there is a complaint, that's not the case. They can simply choose the worst pieces of evidence, and this will certainly, in fact, affect the market, right? So you're gonna have other damages that go beyond just the cost of litigating. So the good thing is that the settlement brings certainty, and everybody just want to have that investigation behind and have this done. Just going back to the neither admit nor deny policy, there's in most of the settlements with the SEC, the defendant neither admit nor denies. This has been the policy for a long time now, and with the new chairman, it's still uncertain if this policy will continue or if the SEC will require admissions. And the other thing that you need to keep in mind is that there are also collateral consequences. There are specific consequences about some status as a well-known seasonal issuer for the purpose of securities offerings. So you can lose the statutory safe harbors under the Securities Act. There are impact with forward-looking statements. And these are some things that are not negotiated with the Enforcement Division anymore. So you would have to request a waiver with the Corporate Finance Department within the SEC. And it's something that you cannot discuss in the settlement. So you need to think about the other consequences as well. Last thing is it's unusual, but the SEC can also recommend enforcement action to the commission without giving any Wells notice. It's really not usual, but it's possible that the SEC goes directly to court and file a complaint. I think on the SEC, these were the most important points that I wanted to cover. So I will turn back to Kyle.
Thanks, Rafael. No, great stuff. And as everybody can hear, there's a lot of overlaps with some of the DOJ considerations, especially from the corporate enforcement context. We had a little bit more material prepared, given how over time we are here, and we appreciate everybody's patience. I suggest we scrap that and just move to the questions, just so we can wrap up quickly. And again, really, it's our pleasure to be here, and we really appreciate the opportunity to chat with all you guys about these really important issues. But the first question, if I'm reading this right from the chat, is from Guilherme about the relationship with auditors. I mean, the audit function, both an internal audit function and the external auditors for companies, usually a very important part of these discussions, right? I mean, in terms of, going back to the compliance program point, the effectiveness of the compliance program, a big part of that could be, the internal audit function and how well that, either was able to ferret out some of the misconduct that you might be worried about, or how that was reported up the chain within the company, and then also how the company might have reacted to that, right? If there was a bad audit report for a particular business unit, for example, how was that then dealt with? So those types of facts are always going to be very relevant to the discussions about resolutions, because the audit is a control function. It's meant to help control and prevent some of the misconduct that you might be worried about from occurring. And then external auditors carry another set of issues. I mean, these are both in terms of their relationship with the company that they're auditing, but also themselves, right? I mean, remember, the first major corporate criminal case was against Arthur Andersen, Enron's auditor, right? And so, there's a very complex set of issues that deal with the relationship with external auditors as well, which is well beyond the scope of what we have time for now, but definitely something to stay focused on. And then the second question looks like comes from Livia about the sort of trend of cases in general, which is something that we're all very interested in and focused on ourselves. Basically the opinion of why things have potentially slowed down. I would say that, the pandemic definitely caused disruptions, right? I mean, it was difficult for, everybody, no matter what you were doing, to adjust to what was going on during those early days when people were being sent home. And it was just a very disruptive time. And courts were closed, grand juries weren't meeting. There was a lot of, investigative activities that were stalled or sort of put off while everybody was dealing with, the disruptions around the world. That is going to end, right? I mean, people are going to be back to work and things are going to be moving in a way that are more expected. I think that is certainly the trend that I'm seeing in the United States right now. And so, I think that, things are probably going to pick up. I mean, you never know exactly what's going to happen, but I think that, there's been a lot of, things that had to be prioritized, right? Violent crimes, for example, that had to be dealt with during the disruptive times of the pandemic, and now perhaps some of the bigger corporate cases are starting to roll with a bit more urgency. But again, I mean, it's all sort of uncertain, right? I mean, we're dealing with a world where disruptions and interruptions to our normal day-to-day are constant, given all the circumstances that we're facing with the pandemic. And so, it's still a bit of, two steps forward, one step back, it feels like sometimes. But I do expect that, under Biden and the administration and, the new SEC chairman, as Rafa was suggesting, there's going to be still a very, concentrated focus on corporate enforcement and trying to put together the pieces of the investigation to make those cases.
Yeah, I just want to make one additional note on Guilherme's question. You see many times when it's like, for example, in an accounting fraud investigation, which of course, like external auditors were not involved, but they were the auditors, right? They approved the financials of the company. So many times what you see is that the SEC will also ask for documents to the external auditor, and the SEC will interview the auditors involved in auditing that company. So I don't know how this is happening in Brazil, but it's very common to see that. And depending on how the investigation goes, it could happen a referral to the PCAOB, which is the regulator that oversees the auditors. I think that's the only comment I wanted to add. I think that's all, Mariana. Just wanted to say thank you, and I'm sorry for exceeding our time. But it was great to be here and had this opportunity to meet with you, and I hope the presentation was helpful. Of course, if there are other questions, you can just reach out to us by email, and we will be happy to discuss any additional questions that you may have.
Yes, well, thank you so much, Rafael and Kyle. I'll let Cecilia close the meeting.
Okay, thank you very much, Rafael and Kyle. In the name of our committee here, it was very, very interesting to hear about your experience and all the negotiations with the authorities in the U.S. Something, part of them are similar to what we see here in Brazil, but there are very interesting insights for our work here. So many thanks again, and hope to see you soon.
Thanks, Cecilia. Hope to see you soon too.
Maybe in person.
Bye-bye. Bye-bye.
Bye.